I have started the recording. Last time we talked about the definition of legal research. We discussed the term sources of law and its three definitions. That is, the origins of legal concepts, the governmental institutions that formulate the rules, and the published manifestations of the law. We talked about the nature of legal authority, and that authority refers to both the type of material and the degree of persuasiveness of that material. We discussed primary versus secondary sources, and we discussed binding or mandatory authority versus persuasive authorities. We then started to take a look at the three areas where government makes law, and we started with the judicial branch and talked about the common law. We discussed the structure of both the federal and state court system and its hierarchical system, where you have trial courts at the bottom, intermediate appellate courts in the middle, and highest courts at the top, and what those courts were. We also discussed the doctrine of following precedent and the three Latin terms, stare decisis, to stand on things decided, ratio decidendi, which is the holding or principle that forms the precedent, and dictum or obiter dictum, which is language that the court says, oh, by the way, if we had gotten to this, this is what we would have done with this matter. Obiter dictum is non-binding, merely persuasive language in a court case that may become binding in the future should someone choose not to follow what the court has said that they are likely to do in a given circumstance. And so dictum is important because while it is not mandatory or binding, it is not the ratio decidendi, it's not the point of law in which the case turns, it is important in giving indications of what a particular court is likely to do in any given situation. We also discussed the fact that courts have leeway in interpreting precedent, as it's rare that the exact same fact situation is presented in a court, and discussed the fact that stare decisis requires that where you do have virtually the same fact situation, stare decisis requires the same outcome, even if you didn't agree with the outcome when it was originally decided. Once the precedent is set, the court is required to follow that precedent, even if the individual judges or justices were not in agreement when that decision was made. Having reviewed all of that, does anyone have any questions about what we discussed previously before we move forward with new material? We won't get a first assignment in here to do research until we've gotten to where we're actually discussing in detail particular materials, specifically case law, so somewhere around chapter 4 or 5. So it'll be a couple of weeks. In the meantime, I'm going to go to the library and film a tour so you'll be able to see the books and what the library looks like, and a few other things that I'll be uploading as I get them done. But hopefully those will be ready for you before we get to those points in the course. Oh, Jessica, I'll be happy to do that. Let me do that right now. Let's see. I have to find where I sent it. Okay. So in the meantime, The next set of materials we need to look at are legislation and the interpretation of statutes. Legislation is a positive statement of law or legal rules enacted by a legislature. And a legislature, a legislative body, is an elective body empowered to write laws. Give me just a second. I'm trying to do more than one thing at a time, and I don't always succeed at that. Okay. No, we're still on chapter 1. I'm on page 7, if that helps. Yeah, we haven't finished the first chapter, much less gotten to the second chapter, although we are getting there. I want to make sure you have a full and complete foundation. Otherwise, the next materials don't make as much sense. So, as I said, legislation or a statute is a positive statement of legal rules enacted by a legislature. This is compared to a constitution, which is a foundational document. That is a constitution is the fundamental body of principles, most often written by which a political body like a nation or a state governs itself. While many of the basic concepts of constitutional and statutory research are similar, we discuss them together, and we will discuss them somewhat together in this course. But constitutional law is a very specialized subject because it underlies discussions of pretty much any other area of law, in that the Constitution sets the foundation for everything. When courts look at statutes and determine that what the statute says is not enforceable, it is generally because they have found it to be in conflict with the Constitution, what we say unconstitutional. And so it's important to have enough information from the Constitution and knowledge of the Constitution to be able to read legislation or administrative law or even other court cases in conjunction with the foundational principles under which a nation or a state is established. With regard to statutory law, which has now gained pretty significant authority. In English law, the king enacted the earliest statutes with the concurrence of his council. Later, the role of statute maker was turned over to the parliament. In this country, statutes are enacted by the legislative branch and then signed into law by the chief executive. So at the federal level, that means passed by both houses of Congress and signed by the president. The state level, it means passed by both houses of the state legislature and signed by the governor. Statutory law has become increasingly important since the Industrial Revolution, when it became pretty clear that making decisions solely on judicial opinions would not meet the needs of society, that there were specialized areas where there really were required to be laws that told us how things work and what needed to be done and how to handle those areas. The key thing is that even where you have statutory law, It does need to be interpreted and applied to individual facts. Statutes are passed individually and signed by the president or the governor. And they're passed in a chronological order where one statute and the next statute really are not likely to have any particular relationship to each other. And sometimes you get statutes that actually collect information or pass laws, make statements about how the law works in a lot of different places all at once. We get legislation that's sort of piecemeal packed with a lot of little pieces from all different places. And so if all you have are the statutes as passed, it's really hard to figure out what the law actually is. As a result, we have created from the statutes something called a code. A code is where you take the statutes and you group them by subject matter, and you insert new additions, and you take out anything that's been repealed. And it gives you the opportunity to look at the code and find all the law on the same subject in one place. So all of the federal law pertaining to bankruptcy is in the bankruptcy code. All of the federal law pertaining to copyrights is in the copyright part of the code. So the act of codification, that is grouping laws by subject matter and then arranging them in a particular order to make it easier to locate the laws, has made statutory research significantly easier to do. Courts have played predominant roles in interpreting and applying statutes and in extending law to subjects not expressly covered by the statute. Legislation is written by committees, by groups of people. And so you often get disparate ideas coming together to make a cohesive or somewhat cohesive whole. In addition, statutes are generally written to be general or generic, to apply to situations in general in society. But court cases are made up of individual facts. And so part of the job of a court when looking at a particular fact situation and a given statute is to decide the extent to which this statute was intended to or should apply to a given fact situation. And that's a pretty complicated investigation in many cases. And it requires what we call statutory interpretation, in that the courts have to interpret whether the person or the entity that wrote the statute intended for this statute to work in this particular way and to apply to given circumstances. In addition, sometimes you have a new statute that's not ever been applied in a particular case, and in that situation, it is up to the courts to determine when or if the law is going to apply. And they do this in part by looking to what we call the legislative history. Legislative history is that combination of documents and information that tells you what did the people who wrote the law intend for it to do at the time it was passed. And legislative history research is one of the ways courts interpret the law. More and more in recent days, they have gone to what some judges and justices call the strict construction role, which is they look at what they perceive to be the plain meaning of the language, regardless of original intent. In those cases, it can get complicated and convoluted in that when reading what is perceived to be the plain language of the law, a strict constructionist can find that the law applies in a situation that the framers of that law not only didn't intend, but didn't even think about. And that's part of the way in which they extend law. Courts can extend law into new and different areas. One of the foremost proponents of this strict construction, ordinary plain meaning of the language formula for interpreting and applying statutes is Justice Neil Gorsuch, who very commonly will look to that kind of a definition in order to reach an opinion on how a law should or should not apply. This was very clearly evident in a recent case decided by the U.S. Supreme Court dealing with Title VII, which is the title of the law that pertains to employment discrimination, wherein Justice Gorsuch held that based on the plain meaning of the words, when the legislators in the 60s said that it was illegal to discriminate against individuals on the basis of sex in employment and in workplace situations, that applied not only to gender, that is, whether you were male or female, but it also applied to any other situation where sex was the determining factor in how a decision was made. And thus it would apply also equally to individuals who were discriminated against based on their sexual orientation or on their perception of who they were, that is, whether they were transgender or any of the variants of sexual orientation or other perception of personhood. And so while the legislature, that is the Congress, probably didn't look at these issues at all when they wrote the employment discrimination law, that is now been interpreted to be wholly a part of that law from the strict plain meaning of the language of the statute itself. And so that's a big change. Statutory interpretation and the different ways in which things are interpreted can make a huge difference in how people look at the law. Any questions about legislation and statutory interpretation? That brings us to the third branch of government that also makes law, the administrative branch. And the third major institutional source of that law is the executive branch. The President of the United States, the governors of the individual states all issue orders and create other documents with legal effect. And then there are executive branch departments and offices and administrative agencies that all create legal information as well. It is the job of the executive branch to carry out the law. Specifically, the legislative branch writes the law, the executive branch carries out and applies the law, and the judicial branch interprets the law. As such, the administrative law generally takes the form of rules and regulations designed to implement what the congressionally created statutory law empowered them to do. Congress passed the Internal Revenue Code and decided what the tax rates are and what deductions you have or don't have, and a timetable for filing your taxes and all of those sorts of things. The Internal Revenue Service, which is an executive branch agency, is then required to create rules and regulations, including promulgating forms and instructions to tell people how to carry out that law. Congress didn't tell us that you file a W-2. The Internal Revenue Service created the W-2 to ask questions that would help you to report the information necessary in order to properly calculate your taxes. So it's up to the administrative agency to write rules and regulations to implement the statutes created by Congress, to put into force and effect the things that Congress has required. The Social Security Administration is empowered to collect and to dispense Social Security benefits, both to senior citizens and, under certain circumstances, to individuals who have paid into the system and who have become disabled. Congress said that they had to provide an application process and an appeals process and things of that nature, but the rules and regulations promulgated by the Social Security Administration created the forms and the process and the timetable and the what happens when you file an appeal and that sort of thing. Rules and regulations have the same force and effect as a statute if they are properly promulgated. So rules and regulations are law in the same way that a statute is law, in the same way that a case decision is law. All of them are law. A rule or regulation is not a statute, that is a law passed by the legislature. It's a rule promulgated, that is created by the administrative agency. It's important to understand that administrative agencies do not have the power to just rewrite the rules and put them into force and effect. We have an Administrative Procedure Act and several other laws passed by Congress that require that an agency act in creating rules and regulations in a certain way. That is, they have to have a calendar for rulemaking that is published twice a year. They have to follow the calendar. They have to write the proposed rules and publish them for people to read. They have to put them out for comment. So normal, ordinary people have the right to comment on the proposed rules before they go into force and effect. And then after the comments period closes, they have to make a good faith effort to review the comments and potentially revise the information on the basis of what took place. That is, based upon the comments, revise the rules in conjunction with those comments that they feel are appropriate to be acted upon. And then they have to republish the rules with notice so that individuals know that these are the new rules, and they have to have been published a minimum of 30 days, and depending on the subject matter, it can be as many as 90 days before the rules themselves go into force and effect. In addition, the president has the power to issue what's called an executive order. An executive order is an instruction to executive branch agencies to take certain action. Most recently, for example, the president signed an executive order to create a payroll tax holiday, essentially to defer the payment of payroll taxes for the remainder of the year. Now, the president doesn't have the power by executive order to change tax rates or to stop the requirement that taxes, including Social Security and Medicare contributions, don't have to be paid. He has the power to change the timetable, the schedule, but he doesn't have the power to make it go away unless Congress agrees, which they have not done so, at least not at the moment. So what's about to go into effect starting September 1st, which is tomorrow, is that companies will have the option about whether to collect or to not collect and to pay in payroll taxes. Payroll taxes are prepayment of taxes that will be due and owing on the 15th of April of next year. The taxes on what you earn this calendar year, which are then due and owing in April. And there are a bunch of rules that say if you don't pay in enough, you can be charged penalties for not paying enough. The IRS is furiously writing new rules and regulations to implement the president's order, but they haven't even had time to write them, much less to publish them and put them out for comment before they go into force and effect. So there's going to be a lot of backtracking on this as time goes on. Unfortunately, our current president doesn't understand that government doesn't work like business. In his business, he owns it and he makes the decisions, and when he wants something to happen, he just says, do this. And he thinks that he can run the government in a similar way. And the problem is that that's not the way our system of government is set up. There are limitations on what the president can do, and there are limitations on what an executive branch agency can do without putting things out for comment, which is why recently the Supreme Court ruled that while the DACA program was created by an executive order, that is, President Obama issued an executive order to the Immigration and Customs Enforcement Agency to promulgate rules about how to run a program, and they did so. The current president said, well, if he could create it by executive order, I can terminate it by executive order, and issued an executive order to terminate the program. But the agency did not promulgate the rules properly when they did them. That is, they didn't write them and put them out for comment before they went into force and effect. And the court said, while the actions taken may be lawful, that is, you have the right to do this, because you didn't follow the rules when you did it, what you did is not enforceable. You have to go back to the drawing board. It's unconstitutional because, or it's unenforceable because when you created the rules and regulations, you violated the Administrative Procedure Act. You violated law by not following the rules on how to do something. And so the big thing in government is you have to dot the I's, you have to cross the T's, you have to jump through the hoops. If you don't, to use a baseball analogy, if you don't tag all the bases, by the time you get home, you're out. You haven't scored a run because you didn't do what you were required to do. You didn't hit all the stops on the road to get to where you need to be at the end, to do what you are intending to do. And so the administrative law creates the way in which we carry out what Congress has said, and the president can and does have the power to issue executive orders. But when implementing those orders, those agencies are still required to apply the Administrative Procedure Act, to follow the law, to publish when a calendar saying when they're going to do something, and then to follow the calendar and to provide opportunity for comments before it comes out. Now, dictum is where a court says, we're not deciding this case on this point of law, but if we had gotten to this point of law, this is what we would have done with it. So it's where you appeal something on multiple points of error, different violations, potential violations of the rules in the court case on one, but they tell you, since we're sending this back for a new trial, you might want to know that these other three things they appealed on, you did those wrong too. So don't do that again. It's not enforceable, but it's very persuasive. On the administrative law, that is the law from the executive branch, just as the courts interpret what statutes mean, they have the power to oversee and to interpret what the rules and regulations mean, but they also are required to review, were rules and regulations created properly? Were the rules followed correctly? In order to ensure that when you have new rules and regulations, they have the force and effect of law because you did all the things you were required to do along the way for them to go into force and effect. So those are your three branches of government and the law that they make. Anyone have any questions about that before I start talking about the materials of legal research? Okay. Great. Published legal resources can be divided into three broad categories. We've talked about the two types of materials, that is primary sources and secondary sources. And technically anything that isn't primary is secondary. However, there are some legal materials that really in and of themselves are not authorities. Rather, they are tools to locate other authorities. And so here the book divides into three broad categories. That is the primary sources or authorities, secondary sources, and index search or finding tools. All of these published resources can appear in more than one format. So you can have printed books and databases and digital images and other materials. So you can find these materials in a lot of different formats, but they equally fall into the category they fall into regardless of how they are disseminated for general use. I am following the chapter page by page. I'm on page 9 and about to turn to page 10. The third is the index, search, and finding tools. Primary sources. These are authoritative statements of legal rules issued by governmental bodies. So that's case opinions and the Constitution and rules of court and statutes, which can be codified into codes, and administrative rules and regulations, administrative opinions, executive orders. All of those are primary sources. The problem with a lot of those primary sources is that they're published chronologically. That is, they are published in the order in which they are written. But the order that they are written in may or may not have anything to do with anything else, because we are nothing if not a scattershot. That is, one case has nothing to do with the next case, etc., which is why you need index search and finding tools to locate materials. Secondary sources are materials about the law used to explain, interpret, develop, locate, or update the primary sources. These are treatises, restatements, loose leaf services, legislative history, law reviews, all types of legal periodicals, legal encyclopedias, American Law Report annotations, legal dictionaries. These are resources that can interpret what's in primary law. They often use textual analysis to analyze the information. They synthesize doctrine and provide critical commentary, some of which can be highly persuasive, some of which may not be. It is not uncommon in looking at a particular case for an appellate court to look to scholarly writings to see how legal scholars are looking at the same area of law. And in some cases, we're persuaded by that writing, be it in a scholarly journal or a treatise or elsewhere. The court may adopt that interpretation of the law. That means that that particular secondary source was so highly persuasive, a court was persuaded to make that particular argument or form of interpretation the actual law. Doesn't make that secondary source primary. It just means that the theories contained in the secondary source were found to be so persuasive that the court applied that theory of law in a case, and the case decision made that particular interpretation law. Index search and finding tools. Because a lot of primary sources are published chronologically, we need other tools to help us locate material. These are things like digest. A digest is a set of books created to help us locate case law by subject matter, because cases are published in chronological order rather than in subject order, and they have generally no subject indexing of their own. You need somebody else to write an index or a search tool to help you locate those materials, and the digest does that. We have legal periodical indexes. We have citors that help us to update materials. When a case is decided, that case opinion is published. Once it's published, it's just published. Nobody goes back. If a court of appeals decides a case and then it goes up to the Supreme Court and the Supreme Court overturns the Court of Appeals, nobody goes back and stamps overturned in the published book. The only way you know that the Court of Appeals decision was overturned by a higher court is by using a citator to look for the history of that case, both prior history and, more importantly, subsequent history. That is, what came after this decision. It's really important to know. You don't want to be in a position where you found a case and it seemed absolutely perfect and perfectly applied to your fact situation, and you don't update it, you don't check to make sure it's still good law, and then you find out that case itself went up to a higher court and got overturned and it's not good law at all. Or that a case came along a day, a month, a year, 20 years after the case you want to rely on and change the rules. If you were, for example, researching segregation and whether or not different forms of segregation were legal, you might do research that located a case from the late 1800s called Plessy versus Ferguson. Plessy versus Ferguson was a case pertaining to railroad passenger cars, and it ruled that so long as equal accommodations were provided, separating the accommodations was allowed. So under Plessy versus Ferguson in this country, the law was separate but equal is okay. That was the late 1800s. In the early 1950s, the Supreme Court revisited the case in a school decision having to do with educational opportunity, and they expressly overturned Plessy versus Ferguson. That new case was called Brown versus the Topeka Board of Education, or what people shorten to Brown versus Board of Education. It's actually a consolidation of 4 cases from different parts of the country. But if you found Plessy versus Ferguson and you didn't do any additional research, you didn't try to update that case to find out what happened after this case was decided in this area of law, your perception would be that separate but equal is okay. Even though in the Brown versus Board of Education case in 1954, I believe it is, the U.S. Supreme Court, in a single opinion with one voice written by the Chief Justice, said explicitly, separate but equal is inherently unequal, and the mere fact of separation creates inequality. That was a very important decision. And it changed the law. It turned more than half a century of how this country worked on its head. Now, they said segregating schools was illegal, but it was not the court's job to integrate those schools. They sent it back for further proceedings and for the school boards create a mechanism and a policy and a process to effectuate what the court ruled. In Plessy versus Ferguson, they said that separate but equal was allowed and that each state could make a choice about whether they chose to separate, but it validated that separation was an allowable thing, that they didn't say segregation was required. They said segregation was allowed, was permissible under the Constitution. Brown versus Board of Education said the principle of separation, that the very act of segregation created inequality. And they sent it back for individual states and individual school boards to make determinations. And they actually expected that over the years schools would do that and there would be a change in how schools worked. I believe that the Warren Court was much more optimistic about what society would actually do than reality. Because ultimately what happened is a lot of schools did nothing for a lot of years. And then over time, they started acting in small ways. They kept arguing that neighborhood schools should be for neighborhood children. Brown versus Board of Education is applying to how you have to use a citator or other research tool in order to update information. And am now going through to explain how, having now had a decision that didn't do implementation, further research using a citator or other updating tool would lead you to find that there are a whole line of additional cases from the 60s and 70s where courts actually had to take over school districts to implement what was required under Brown versus Board of Education, because neither the legislatures nor the school districts took it upon themselves to do what the decision in Brown versus Board of Education told them to do, which created additional litigation. And so when you look at Brown versus Board of Education in a citator, that citator is going to cite you to hundreds of cases throughout the country where Brown was applied in order to explain why a court is ordering people to take certain actions. Ultimately, there were a lot of school districts that ended up, due to their systemic and inherent discrimination, being supervised by federal courts. The Dallas Independent School District was under federal court supervision for over 30 years, where every time they wanted to change individual school attendance zones, or wanted to open a new school, or to change the curriculum, or to do lots of different things, is a way to learn what happened next and how did the system work.